Добрий день. Після короткого відпочинку продовжуємо
Good
нашу
afternoon. After a short break, we'll continue our session that is going to deal with judicial protection of fundamental electoral rights of citizens. We have up to 15 minutes for the presentations. Following the presentations, you can raise the questions either in the chat or by raising your hand, but this can be done only after all the presentations. After all the presentations, we are going to have Q&A. We have simultaneous interpretation, English and Ukrainian. Secretary of the Grand Chamber of the Supreme Court, Mr. Knyazev, is in the middle of the hearing. He's going to join us later. That's why we have some changes in the order of the presentations. The first thing I'd like to note is that in Ukraine, we see lots of ongoing reforms. One of them is decentralization reform that deals with local self-government. The concept of the reform of local self-government and territorial power in Ukraine covers the elements of the reform. And in 2015, as part of this reform, we saw the process of amalgamated communities being established. And that was the very time that gave rise to many disputes. The comparison of the local elections and the role of local elections in providing for electoral rights. So that's what is going to be covered by Miroslava Bilak, judge of the Supreme Court in the Administrative Cassation Court. Dr. Floor. Good afternoon, dear participants. We have some misunderstanding because in the program I was to speak about the fair procedure application in the election process, but the subject matter that was announced by Olena Hubska was part of the collection of articles that was announced by Madam Kalashnikova. So, dear participants, let me talk about the issues and subject matter that is stated in the agenda. That's the issue that is related to the fair procedure. Why procedure? Because whether the Supreme Court or the Administrative Cassation Court that is resolving the disputes between the person and the state is protecting the rights of the person primarily. And the Supreme Court is governed by the fair procedural doctrine in its work. And for us, it was very important, especially at the very outset of our work after the reform, when we started introducing various doctrines borrowed from different legal systems. And one of the doctrines that we followed is the doctrine of fair procedure. We have lots of versions of translation of this doctrine into Ukrainian, and even at this moment we haven't finalized the translation. And I'm really pleased that this doctrine is of interest for the colleagues, and one of my colleagues, Radishevska, defended her doctorate thesis where a lot attention is paid to the due process doctrine. Why are we talking about this issue? Why fair procedure doctrine is so important? Well, because that's related to the question whether the courts are entitled to correct the election procedures that deals with the winning candidates and the procedure itself. So that was something that we spoke about at the beginning when we talked about potential revocation of the election results. Well, especially that's important when it comes to the recognition of the elections as the one as took place. If so, then what tools were engaged? Apparently, so we need to be guided by respective principles here and criteria. Kalashnikov and Pilkovich spoke about the absence of the codification of the systematization of legislation and the role of courts in this regard. We are aspiring for the uniformity of case law, but if you talk about this particular issue, the courts cannot create new standards to convince that the position is right, even if it is a new position that the courts come up with. Every time there will be some new things that would have an impact on the results. And it's very important to remember who makes the decision: authorized body, Central Election Commission, so a legitimate authority in the state. Therefore, fair procedure is so important. It should be determined by the legislative provisions. And it's very important in the election dispute resolution, as Mr. Kuchkovsky said, that was on the election law. The specificity of the norms are because they are barriers of imperative norms aimed at limiting the rights of the power entity. Article 6 of the European Convention is an indispensable part of national legislation in our country. It's very important for any type of procedure to be governed by legal standards and fairly apply them. And that's exactly what Article 6 of the Convention means. Fair procedure doctrine is the requirement, a legal requirement, whereby the public authorities in the course of decision making are governed by fair law. The Supreme Court in its resolution in July also spoke about that, and that's an element of the rule of law and provides for legal requirements. In other words, the subjects of law, especially the officials, should exercise their powers and act lawfully under the law, under the criteria of ethics and morality. Article 6 of the Convention, paragraph 1, echoes Article 129 of the Constitution, whereby the judge of an administering justice should be independent and be governed by law. The courts, therefore, not only establish the standards of fair procedure, but the principles of the respect to others, the right to be heard, the courts thereby limit the powers of public officials and prevent violations. How we can apply the principle of fair procedure in the election process? Scholars speak about universal principles and values that should be applied in any election process to resolve disputes, and therefore this would provide impartiality and fairness of authorized authority. That's respect to voters, to all of them, and each of them separately. Along with that, the principles include any efforts and attempts to intentionally change the results of the elections. And here we are talking about proportionality of tools to pursue the goals. And we need to have a clear-cut procedures defined by law for the public authorities to exercise their powers. And these procedures actually limit discretionary powers of public authorities and determine their lawfulness. Clear-cut procedures is the duty of the state, because in case of arbitrary actions of public authorities, they serve as the basis for appeal of the person whose interests were affected.
Today, Elena Kalashnikova and other colleagues have focused on various legal positions that have already been made by the Supreme Court, including the positions related to activity and inactivity of the authorities. And within the context of my presentation, I'd like to focus on the case of the Supreme Court 95/1, where a political party requested to find inactivity of a CEC as regards the failure to establish election results at one of districts at the interim election and enforce it to make certain actions. This case is related directly to another case that the Grand Chamber of the Supreme Court heard on the 1st of May 2021 that we all know, which revoked the CEC protocol on establishing election results at one of the election districts or constituencies. And that decision found that it was impossible to establish clear voting results, which puts under doubt the results of the election in general. Finding a solution to the dispute, as the Grand Chamber decided, as there is no clear mechanism for solution in the law on the election, suggested that the Grand Chamber and the CEC should have used the discretionary powers. The Cassation Court of Appeals in that case stated that the CEC found itself in a situation that it was to resolve without the presence of proper mechanism in the law. We all know that the CEC, as an executive agency whose powers have been confirmed, discretionary powers have been confirmed by the Grand Chamber, to which it referred, was to implement those discretionary powers according to Article 19 of the Constitution of Ukraine and Part 2 of Article 3 of the law, according to which the Commission and its members are only to work on the basis and with the competence established by the Constitution of Ukraine and other laws of Ukraine. Discretion does not mean that one can use it to replace the law. That should have very clear definition of the election procedures. As a result, some international lawyers, they also suggested to change the definition for the election procedures that should be in the basis of the election law. There's legitimacy, transparency, finality, non-politicization. In view of those suggested principles or concepts or definitions, one could bring it down to formulate them, to bring them down to three texts. So solving the result of the election in a correct way within a proper deadline, and carrying out the previous two functions to make sure that the election is fair and correct and legitimate. So when we talk about discretion of the Central Election Commission, it has to be clearly limited as it is used, applied. The society should be sure that the agency works in an unbiased and fair way. That's why the procedures have to be clearly defined in the law, because they are the criteria for legitimacy. The guarantees of procedural fairness and justice, even if a decision of the body had negative effects for a part of the society, should leave everyone convinced the material substantive part was never violated. And that's how it would form the trust of the people to the power as regards its non-politicized nature. Thank you. Thank you, Ms. Pilak, for this very interesting presentation. I am sorry, it was my mistake. In fact, when I suggested a different subject for your presentation. So you now, in fact, have made almost 2 presentations, or 1 presentation for both, in both areas. Thank you very much for it. We will proceed now to the next speaker. We have a guest from Georgia, President of the Constitutional Court of Georgia, retired, the former Minister of Justice, the expert of the European Commission for Democracy through Law, the Venice Commission, Professor, Doctor of Law, Georgi Papuashvili. Please, the floor is yours. The effect of constitutional decisions on the election law, the experience of Georgia.
Thank
you, Olena. Dear colleagues and friends, I'm very happy to welcome you all. I'm happy to be able to participate in this conference. I want to thank you for the invitation to speak and tell you about the experience of Georgia, about the impact of the decision of the Constitutional. I'm sorry, the connection is bad. Switch to off. I will try to make my presentation shorter because we're behind schedule and it's the end of the day. So the rights of the judiciary should not be ignored because you have many other things to do. I'd like, first of all, to congratulate Ukrainians with soccer results, because 2 days ago, all of Ukraine, whatever professions you had, but judges are also people, and they also rejoiced. And I hope that victories in other areas of Ukraine will also benefit Ukraine as well as other countries. Now, I would like to use my 15 minutes or even less to make my presentation. It's just that I prepared it in English, so I will now proceed to English.
The constitutional review may play a significant role in shaping the framework of electoral legislation. When deciding cases concerning the right to vote, electoral system or electoral process, as well as hearing other proximate matters in view of fundamental rights, the standards developed by constitutional tribunals may substantially change the rules for political subjects and voters alike. In many countries which adopt centralized model of constitutional review, like in our countries, the constitutional courts are also tasked with adjudicating electoral disputes. That's the constitutionality of election results. And yet, before turning to the Georgian case, it's of great pertinence to refer to other instances when the Constitutional Review Court could determine the systemic aspects of electoral system and thereby influence the political climate in the country. I just want to recall one case of your primarily neighboring country, Moldova, where the court used a very activism approach and it declared unconstitutional changes in 2016 to the constitution on account of the interpretation of the constitutional rule that the draft constitutional laws shall be submitted to parliament only alongside with the advisory opinion of the constitutional court. And the court declared unconstitutional the law amending the constitution on the election of the president of the Republic of Moldova by parliament with a vote of 3/5 majority of members of parliament. And the law on election of the president revived the provisions of the electoral code on the election of the president by direct vote of the citizens and the provisions of the rules of parliament that allow the essential modification of the draft law on which the Constitutional Court delivered an opinion. So this decision provoked a lot of discussions and controversies, but it showed that how the decision of the Constitutional Court may influence the whole system of the election systems in the country. So to come back to Georgian realities, at first, let me briefly overview the system of election disputes. The Constitutional Court, similar to a number of constitutional tribunals in Europe, has the power to decide on the constitutionality of norms regulating referendums or elections and the constitutionality of referendums and elections held or to be held based on these norms. On the basis of a claim submitted by the President of Georgia, by at least 1/5 of the members of the parliament, or by the public defender or physical or natural persons of Georgia if it's related to the human rights provisions of the Constitution related to the elections. It's noteworthy that as a result of the recent constitutional amendments in 2017, the powers of the Constitutional Court was limited in respect to hearing cases upon electoral matters. Namely, as of today, the Constitution explicitly stipulates a legal norm regulating elections shall not be recognized as unconstitutional by the Constitutional Court within the respective election year unless this norm has been adopted within 15 months before the months of the respective elections. So if the legislation is a bit older than 15 months adopted by the parliament, the court is not allowed to make a deliberate decision. It can be construed here that the constitutional legislator had clearly favored the stability of electoral legislation in the election year over the potential unconstitutional norms that might exist in a given period of time. While the case law of Constitutional Court is limited in respect to this particular competence of election disputes, and it's mostly up to the administrative courts and ordinary courts, there are a couple of cases that court decided mostly in early 2000 years, not in recent years. In contrast to the disputes related to the final result of elections, the Constitutional Court has extensive case law in view of the fundamental rights, such as the right to hold public office, right to participate freely in elections, electoral matters concerned, the right of equality and non-discrimination. So, right of equal suffrage, for example, in 2014, in its landmark case, which challenged the provisions of election code regulating the boundaries between electoral districts raised by physical persons, the Constitutional Court held that although in majoritarian elections it's particularly impossible to ensure absolute equality between the weight of votes, since there will always be comparatively smaller and bigger districts which will elect the same number of members of the parliament. However, the election system that gives more weight to votes of citizens registered in one district compared to others registered in another district does not create equal opportunities for voters to equally influence election results and causes significant deviation from the principle of equality of votes. More concretely, the claimants challenged the constitutionality of norms which stipulated that the parliamentary elections in 73 districts coincide exactly to the rayon system of the country, so the territorial arrangement of the country. And each municipality, including Tbilisi, but Tbilisi was divided in 5 zones. These norms were disputed with regard to the constitutional provisions on equality before the law and the right to vote. The Constitutional Court noted that right to vote doesn't require any particular electoral model to be implemented, but the existing model must ensure free and equal representation of the popular will in the formation of the government. The number of single-mandate districts created varied greatly in the number of votes. For example, the mountain district of Kazbegi registered voters were 20 times fewer than one of the districts, for example, in Tbilisi, or 70 times fewer than in another district of Tbilisi. So, the court reviewed the proportionality principle of votes and referred in its judgment also to the notorious and highly quoted instrument, the Venice Commission's Code of Good Practice in Electoral Matters, adopted by the Commission in 2002. And in these studies, the Commission noted that, for example, the permissible deviation from this principle may not go above 10% among the districts. And just in exceptional cases, it could be 15%. Exceptional cases could be related to the protection of rights of minorities, to geographical position, mountain regions, etc. But maximum still 15%. So the foregoing judgment spurred the electoral reform in Georgia. Parliament was not happy because it took a long time to redraw the boundaries. It was hardworking, but finally they managed to change the legislation. And it's noteworthy that in a similar way, other constitutional tribunals also in Europe also decided upon electoral legislation in view of the principle of proportional representation that laid the groundwork for electoral reforms. And I would note Lithuanian, Italian, and Czech examples. Here are our colleagues from Lithuania and from, no, sorry, we don't have yet from somebody from Italy, maybe in future times. So, for example, in 2015, the Constitutional Court of Lithuania declared the electoral legislation under which the number of voters in a single-member constituency may lead to a difference in the number of voters of up to 50% among separate single-member constituencies as unconstitutional. In view of the fact that the voters in large cities are more supportive of certain political parties, whereas voters in rural areas favor other political parties, it can be assumed that differences in the number of voters in single-member constituencies are artificially maintained for political purposes. For this reason, the electoral process is not fair and not transparent, and this provision was declared unconstitutional. Our colleague from Lithuania, president of the Administrative Court, could add some more about this. About Italian case, which is also a recent case, in 2017, also, the Constitutional Court of Italy made the decision which also influenced greatly on the electoral system in Italy. The majority, he ruled on electoral matters, so-called the majority bonus rule vis-à-vis the right to vote and the right to proportional representation of the citizen. The court struck down provisions establishing that in cases in which no single list had reached the 40% minimum threshold necessary to receive the majority bonus, there would be a round of voting between the two lists winning the most votes. The court held that this way of artificially creating winning lists excessively compromised the constitutional principles of the equality of the vote and representativeness of the elected body by radically reducing vote options in the second round of voting through overly strict requirements. The court also struck down provisions allowing head of list candidates elected in more than one multi-member constituency to arbitrarily choose the one in which to be elected without any stipulation of objective criteria, holding that this allowed for a distortion that compromised the freedom of and equality of the vote. So in Czech Republic, most recent case in February 2021, so even pandemic could not prevent the Constitutional Court sometimes to rule about serious matters. This is the case also in Czech Republic. The Constitutional Court ruled on the interpretation of the principle of proportional representation prescribed by the Constitution. The court held that the principle requires that all the relevant parties gain a portion of seats equal to their overall election results at the national level. The court said in announcing the electoral rulings that so-called don't system used for proportional representation, one of the systems, is not problematic. However, which was used in Czech Republic, is not problematic. However, having 14 electoral regions of unequal size in the Czech Republic, in tandem even with the don't method of allocating mandates, thus significantly undermine the principle of equality of electoral votes. In addition, this is briefly about other cases. So, to come back to the Georgian case about different areas, access to participate in elections, for example, I will name some of the cases. In May 2017, the court adopted a judgment on so-called Kukava case. Under disputed provisions, person was not allowed to participate in the local elections unless this person permanently resided on the territory of Georgia for 2 years prior to elections. The complainant considered that state has no right to introduce residence requirement for enjoyment of the right to stand for local self-government elections, as no such requirement is stipulated in the Constitution. So the Constitutional Court noted that introducing requirement for taking the elective office is not incompatible with democratic governance. But at the same time, the court considered it unacceptable to introduce restrictive requirements which are not provided by the constitutions for the elections, which should be held according to the Constitution. So it ruled unconstitutional this requirement. In earlier case, in 2016, the Georgian Constitutional Court assessed the constitutionality of the provisions of the election code, which barred the initiative group of citizens as opposed to political parties' election blocks from the possibility to nominate a candidate for the mayor office of Tbilisi or for other self-governing cities. The parliament argued that foregoing regulation ensured the development of a party system, also promoted the effective functioning of the local bodies. Considering the context of the case, the Constitutional Court found the restriction of the right of citizens to nominate a candidate of their choice for elections unjustifiable and excessive. In a 2014 case, it's also related to the so-called initiative groups, initiative group, heard the case that challenged the provision of election code pursuant to which majoritarian candidates of parliament nominated by initiative group were obliged to deposit certain amount of sum to be registered as candidate, as majoritarian candidate, by the Central Election Commission. According to the disputed norms, in order to register the candidate for a member of the parliament, representative of the group of voters should submit to the relevant district commission some amount of money deposit made by the majority candidate for an MP. The amount deposited on the amount shall be fully refunded to the candidate only in case if the candidate receives at least 10% of the overall votes in the elections. If not, this amount shall be transferred to the state budget of Georgia. It was an interesting case, and Constitutional Court indicated that generally the state should enjoy the wide margins of appreciation while regulating such important spheres as assurance of conducting the electoral process based on the democratic principles. The electoral deposit was also deemed among them as the effective way sometimes. However, this institute should not give rise to the impossibility to enjoy the right among them. It doesn't have the content which will substantially, perceptibly, significantly distance the persons from equal chances for enjoyment of the right. It should not create the disproportionate threat to enjoyment of the constitutional right, and this provision also was declared unconstitutional. And one last case about status of individual guarantees of directly elected officials. In 2014, also the court in another case where the claimant was at that time acting mayor of Tbilisi, Gulava, challenged the constitutionality of one of the articles of Criminal Procedure Code, which regulated dismissal of an official elected with secret, universal, equal, and direct suffrage if he was charged with a criminal offense and risk was present, that is, his continued occupation of the office would obstruct an investigation. Not dismissal, sorry, but the more correct word would be suspension from the official position, temporary suspension, until the investigation is going on, when the person is not jailed and is not sentenced yet, but it's under the investigation. The Constitutional Court deemed that interference in the right guaranteed by the Constitution did take place, namely the limitation of the right of the elected official to carry out duties interruptedly granted by Tbilisi voters for the duration of 4 years via secret, universal, equal, and direct suffrage. However, in the context, the constitutionally protected right is not limited to the applicant's private interest, but it's also connected to such an important public interest as is the realization of the voter's will. Therefore, when elected high-level official is suspended for an indeterminate period of time because the investigation may go on for a long time, there is no limit, strict limit when person is not in jail. This may effectively equal to removing him or her from office, which renders the restriction of the right a particularly grave, intense character. Furthermore, the law has not stipulated mechanisms to either substitute or review this temporary measure until the final court judgment is delivered, even if there is no objective need and ground to continue imposing it. So that's very briefly, because the details are too much. So I wanted just to show that constitutional courts, and as our German colleague in the introductory speech said, the constitutional courts are siblings of administrative courts. Sometimes they are siblings, sometimes they are cousins, sometimes siblings competing with each other also. But the constitutional courts also play important role, first in protecting the constitutional election rights, which is just under the constitutional court, and second, sometimes as a negative legislator, they may influence the whole development of the election legislation in specific countries. Дякую вас.
Пане Георгію, дуже дякуємо за ваш
Thank you, Georgi, for your presentation. In the course of 15 minutes, we've heard a lot, and the influence of the Constitutional Court and the role of the electoral legislation, not only in Georgia, but other countries. Thank you very much for your detailed presentation. Let's move on. Apart from special provisions of election legislation, administrative code is applicable to electoral disputes, and the administrative code says that if effective legislation is not in line with the constitution, then the constitutional provision prevails and is applied. And the next speaker is going to share with us his insights as to the resolution of electoral cases, namely whether there were any instances when law was not in compliance with the Constitution. If there were no instances like that when delivering or deciding on the decision, so what is it that the court is guided by? Purely by the Constitution or what else? So the presentation is going to be made by the Judge Rybachuk, Secretary of the Judicial Chamber on cases on protection of social rights, who is going to speak about direct application of the constitutional norms by courts. Good afternoon. Very happy to welcome you here at this conference. Let me thank the organizers of the conference for the opportunity to participate in the conference. And could you please show my slides? Dear participants of the conference, I'm going to speak about the direct application of the constitutional norms and how courts and other institutions apply this tool. So this phenomenon is multifaceted, and that's potentially gives rise to the discussability of this issue as to its practical application. And that was repeatedly pointed out by different scholars. Direct norm of the Constitution is seen as one element of the rule of law, as a constitutional principle, as the principle of the constitutional order. Understanding of the direct effect of the Constitution in practice and in doctrine is linked to the recognition of direct effect of the constitutional rights and freedoms of the person and citizen. If you analyze the theory of the direct effect of the Constitution for both systems, whether that's an Anglo-Saxon continental system of post-Soviet states, proves that there are differences when it comes to interpretation of the principle, and the differences are linked to the specificities of understanding of the essence of the Constitution and rule law and correlation of national, supranational, and international law in the legal system, specificity of the perception of the constitutional concept of the fundamental rights of human rights. The key role is played by the implementation of the model of the constitutional oversight and the structure of the system itself. Article 8 of the Constitution of Ukraine states that constitutional norms are norms of direct effect, and it provides for the guarantee to judicially protect the rights and the freedoms of the citizens of Ukraine. Despite the principle of direct effect of the Constitution, the doctrine is being shaped in Ukraine based on two approaches, narrow and broad. The first approach is providing the direct effect to all norms of the Constitution. The second, therefore, applies the fundamental law only when it is necessary to protect the rights and freedoms of citizens of Ukraine. I'm not going to speak about the arguments in favor of either or approaches. Let me just say that direct effect of norms is linked to the opportunity of the latter to have effect on public relations through governance. So the effect is the features of all provisions that have an effect on all the subjects. And the effect is not always enforcement of the right. Enforcement of the right takes place when the effect of the constitutional norm was resorted to by the subjects, and the regulatory influence was aimed at entities. So application or enforcement, that's the most important element when it comes to the direct effect of the norm. So we are talking about the de facto influence that is revealed through the application in the process itself. Next slide. Ukrainian legislation focuses on the effect of the Constitution. At least it allows to single out two aspects of direct effect of the Constitution to differentiate direct application and direct effect of the Constitution. The first aspect is linked to the fact that it covers all elements of its realization: application, abidance, execution, and application. It allows to link the direct effect of the Constitution with the analysis of use of constitutional provisions by private individuals and entities that are deemed to be public authorities. So the difference depends on the status of the entity, its role in public authority, and the type of activity. Apart from that, direct effect is revealed in the fact that to to apply the Constitution, we needed to consider lawmaking aspect. It means that all lawmaking entities should be governed by the effective constitutional provisions. The second aspect provides for the application of constitutional provisions when resolving disputes, irrespective of the detailization by sectoral laws. And if there are gaps, then the Constitution acts instead of the laws, sectoral laws. The theory of the direct effect of the fundamental law, we are repeatedly proved by the Constitutional Court decisions. In particular, we can single out three decisions where the Constitutional Court tried to interpret the constitutional provisions as the provisions of direct effect. The first was the case number 4P/2001 of April 19, 2001. Second decision of the Constitutional Court to interpret the Constitution as the constitutional provisions of direct effect. That was the case that dated 2008, and the third decision was of the case of 2016. Let me focus on the case 12 RP 2008, since the Constitutional Court in its judgment, due to lack of respective legal provisions that deal with early termination of the powers of the member of the parliament, said that the Constitution has direct effect, irrespective of the laws that may be adopted or not. Article 81 of the Constitution of Ukraine says that the highest body of political party takes decision on the early termination of the powers of the People's Deputy, and this should be done given Article 8, paragraph 3 of the Constitution of Ukraine, direct effect of the constitutional provision and effective legislation. This conclusion of the Constitutional Court serves as the basis of the scientific doctrine. So direct effect of the Constitution means that implementation of the fundamental law should be provided both with the presence and in case of absence of our respective legislation. And the Constitution directly speaks that unless we have the procedural law, we have to act under the Constitution. We should not refuse applying them, especially when we talk about the protection of the rights and the freedoms of the person, claiming that there are no legal acts to support that. The issue as to the priority of the provision as to providing the mechanism of direct effect of the constitutional provisions are linked to the work of the judge. It is natural that following the judicial oversight model that is implemented in Ukraine, we expect the Constitutional Court to do that decides on interpretation of the Constitution and violations and constitutionality of laws. As to the role of other laws in application of direct effect of the provisions, that's the subject matter for the discussion. But I believe, however, that effective protection of persons and legal entities can be secured only provided that we directly apply a Constitution by all courts in specific cases and effective judicial control over all lawmaking authorities. This is contributed by Article 7 of the Administrative Code of Ukraine, paragraph 1. Article 7 of the code establishes that the court decides the cases under the Constitution and laws and international treaties. The consent to that is provided by the Parliament of Ukraine. Paragraph 4, Article 7 stipulates for the necessity of the application of the constitutional norms as a direct effect norm. So if the court decides that the law or other legal act is contrary to the Constitution. Next slide, please. It is worth noting that back in 1996, the plenary session of the Supreme Court of Ukraine tried to clarify the provisions that deal with the direct application of the Constitution. The explanation was provided in the resolution of the Congress of November 1, 1996. It is numbered 9. The resolution is important even at this stage. At the same time, we shouldn't treat direct application of the constitutional provisions as absolute. Constitutional provisions can be applied directly when resolving specific disputes, not only by courts but other authorities that are involved in application of the law. And let me move over to practical aspects and quote some specific cases when courts or other judicial institutions made the conclusion that constitutional provision should be applied as the provisions of direct effect. Next slide, please.
Slide number 12, якщо можна.
Slide number 12, please. You may all remember quite well, quite a high-profile and symbolic case that was called the case of Yushchenko versus CEC of 2004. That case is one of the examples when, with the absence in the law of proper provisions, the court came to the conclusion that in order to reinstate the violated rights, it had to use the mechanisms that suggest direct application of the constitutional provisions. You may remember that the court decided in that case that serious drawbacks had taken place during the election process, falsifications that led to impossibility to establish the real choice of the people, and guided by the principle of the rule of law, having applied Article 8 of the Constitution of Ukraine inter alia, it considered those actions to be illegitimate, and with the absence of specific provisions in the law, it came to the conclusion that it had to provide protection to the right by obliging the Central Election Commission to appoint a re-election that were not clearly established by the law. Next slide. There have been other situations in the Ukrainian history where not only the courts but other bodies applying the law use the principle of the direct action of the constitutional provisions. In particular, one can cite here the resolution of the Central Election Commission of the 5th of 11, 2012, number 1931. That was the case about the parliamentary election in several constituencies, several districts, where the court also found that the real choice was impossible to establish as serious falsifications had taken place. And the Central Election Commission made its decision. The CEC adopted the resolution number 1931, according to which it said that it was impossible to establish the voting results for the MP election of the 28th of October 2011 in a number of districts. And because of the impossibility to establish the persons who would become MPs, the CEC decided that there were grounds to make a decision to appoint re-election in the contested districts, and requested that the Verkhovna Rada make the appropriate decision in those constituencies. Besides, as an example of applying constitutional norms as direct action provisions, we can also cite the case related to quite recent developments, the election of 2021 at the district number 87, We all watched those events. We know how they developed. There have been a number of court decisions which inter alia suggested active participation of the CEC and the decisions to be made by it, which the CEC did, in spite of the fact that the Supreme Court, the Grand Chamber, when it made its decision, did not clearly say that they were guided by the provisions of the Constitution as the direct action provisions, but it was clearly seen from the content of their decision. I am very sorry, but your time is up. Thank you. I am about to conclude, and this can be seen from the resolution of the Central Election Commission of the 19th of May 2021, number 214, where it did not have direct provisions in the current legislation, still concluded that it needed to work in that way by using the constitutional provisions as direct action provisions. To conclude, I want to say that proper protection of the rights is possible only where the constitutional provisions would be used as direct actions, not only by the courts, but by the other bodies that apply the law. That's briefly all. Thank you for attention. Thank you very much for your presentation. You had some very interesting considerations as regards the Constitution and the impact of the Constitution on administrative justice and the administration. Thank you very much for your presentation. Thank you for attention. We know that during election campaigns in Ukraine, there are very many observers. The observers not only are national ones, but international ones. And this has become an important mechanism to ensure fair and transparent elections. At the presidential and parliamentary election campaigns, very many missions have participated, the OSCE mission, the European NMO network, including the international mission of the World Congress, Ukrainian World Congress. At the moment, we have the president of that international mission of the Ukrainian World Congress, who observed the election of 2019, Eugene Choly. Yevhen Yaroslavovich is also the president of the NGO called Ukraine 2050. This NGO cooperates with Ukraine and international organizations to develop a joint vision for the future of Ukraine, so Ukraine could become a democratic, European, and independent organization. And we have seen in the media after the elections of 2019 and 2020 very many comments made by Mr. Choly, who in fact pointed to a number of recommendations as to what should change, what should be amended in the current law, what other things that need to be carried out. I'm giving the floor now to Eugene Choly, who's going to talk about improving voting rights, electronic voting, and countering disinformation. Please, the floor is yours. Thank you very much, Elena. First of all, I'd like to greet from Canada, the Supreme Court, and thank you for the organization of this very important, successful international scientific and practical conference, virtual conference, and to thank the President, dear Ms. Valentina Danishevsky, for the invitation to participate. During the latest presidential and parliamentary election campaigns in Ukraine, I headed the international mission of the Ukrainian World Congress to observe the elections of 2019 in Ukraine, and I had a chance to personally observe how the election law was applied. The Ukrainian World Congress mission consisted of short-term observers who watched the election process in Ukraine, as also the voting in the Ukrainian diplomatic missions in other countries where Ukrainians reside. The Ukrainian World Congress mission also included long-term observers from about 30 countries who, in 30 languages, monitored the media to see whether there was any disinformation in Ukraine in general and during the election campaigns. The subject of my presentation is improvement of voting rights. Let me first of all name 5 most important recommendations of the UWC missions in regards to the election process. Number 1, to make sure that the debates between the presidential candidates should take place at least a week before the voting day and not only several hours before the day of silence, to give proper time for the Ukrainian voters to completely understand the essence of the debates. Number 2, to legislatively revoke the day of silence as an obsolete procedure that does not take into account the important role of the social media that the limitation does not cover. 3, to make sure that equal conditions are provided in the media space for the candidates of various political parties. Number 4, ensure that the establishment of the results of the presidential election should be over by the second round of the voting, because in 2019 that process theoretically could have lasted up to 21 days and end up only on the day of the second round election. And number 5, to study some new initiatives that would make it easier to participate in the elections for the Ukrainian voters abroad, who often had to cover very long distances in order to vote, including by increasing the number of stations or precincts in the foreign voting district. Let me speak about 2 most important issues: electronic voting and countering disinformation in the course of the election process. As I was getting ready for this presentation, I remembered the extremely difficult circumstances in which Ukraine had its presidential and parliamentary elections in 2019, namely amid the Russian hybrid aggression against Ukraine, which included armed actions in east of Ukraine, occupation of Crimea, acts of terrorism, cyber attacks, and very powerful disinformation against Ukraine, and which in fact they took away homes from 1.5 million of IDPs. Even in the days of the parliamentary and presidential election, the special monitoring mission of the OSCE documented more than 70 violations of the ceasefire regime in eastern Ukraine. In spite of all those challenges and obstacles, almost incredibly, Ukraine conducted democratic parliamentary presidential elections in 2019, which was confirmed by the international observers. Therefore, I compared the Ukrainian election campaigns with extremely controversial presidential elections of 2020 in the United States of America. And for the first time, it came to my mind, as regards the election process in Ukraine, that the famous English proverb, if it ain't broken, don't try to fix it. The CEC data also confirmed that more than 70% of the voters came to vote during the presidential election in 2019, which means that the Ukrainian voters have a high level of trust to their election system, which is a very positive phenomenon. However, the CEC data also shows that the presence of the voters abroad was only about 13% during the presidential election and 14% during the parliamentary election, which was mostly caused by the long distances that the voters had to take in order to implement their election right. So the UWC missions suggested different options to improve the situation, among which was electronic voting. The issue of electronic voting becomes all the more relevant today when the world is living through the COVID-19 pandemic, further hybrid Russian aggression, including thanks to huge funds that go into bots and cyber attacks and dissemination of information, disinformation, and as we see, digitization of Ukraine. So in order to develop a position in Ukraine about the need to introduce electronic voting, one needs to take into account the experience of other countries, starting with Estonia, which became the first ever country that used internet voting during its parliamentary election of 2007. The voters were authorized within the system with the help of their ID cards, which allowed them to vote. During the parliamentary election of 2015, the Estonian voters out of 100 and voters from 116 countries of the world participated in the voting via internet. In 2019, at the parliamentary election in Estonia, more than 43% of all the votes were cast online. It's also useful to take into account the experience of other countries that partially use e-voting, namely Australia, Brazil, India, Canada, France, the United States, and Switzerland. Positive sides of electronic voting are the comfort in making one's choice for the citizens of Ukraine, including the ones who are outside of the territory of Ukraine, engaging the voters who are not very active, and the voters who live in the territories with difficult access, better protection for the voting results, and in the future, lower costs for the election process. The biggest challenges for electronic voting remain the computer viruses and cyber attacks, as well as quite high costs to introduce secure systems for electronic voting. Eventually, a perfect electronic voting clearly is more modern, sophisticated, and a more secure way to vote for the voters compared to the traditional voting ways. Therefore, in view of the growing digitization in Ukraine, electronic voting needs to be tested and improved. However, I believe that electronic voting can be introduced for the future election processes only when the government of Ukraine will be able to protect at a plausible level from computer viruses and cyber attacks, as well as provoke huge trust to electronic voting with the large ranges of Ukrainian nationals and the international community. As to the second issue, in terms of countering disinformation during the election process, one needs to first of all realize that disinformation is an important part of the hybrid aggression that the Russian Federation is openly waging since 2014 to get Ukraine back into its area of influence and regain control over Ukraine. As to the scale of this disinformation, this is what 6 years ago, on the 3rd of November 2015, the former Deputy Assistant State Secretary of the United States said, Benjamin Ziff. He said it while he testified to the Subcommittee on Cooperation in European and Regional Security of the Committee for Foreign Affairs of the U.S. Senate. I quote, Kremlin is sponsoring those efforts with a refined propaganda machine that costs $1.4 billion a year in its own territory and abroad, the scale of which, according to his estimates, cover 600 million people in 130 countries of the world, in 30 languages. The Russian government is also funding research centers and organizations in the neighboring countries that should promote its objectives by spreading false Kremlin narratives, by depicting the West as a threat, and by undermining trust to the independent media and Western values. The disinformation narrative during the presidential parliamentary elections in Ukraine of 2019 were quite different, versatile, were spread in many languages through traditional and social media. The target audience was not only the Ukrainian people, but the international community as well. A large part of those narratives disseminated, promoted the idea of falsified parliamentary presidential elections with the falsified or fake candidates. This information had to undermine the whole election process and all of the candidates in order to provoke mistrust of the Ukrainian voters to the elections in general and to portray Ukraine as a failed state that does not deserve attention of the international community. All these disinformation narratives were completely discarded internationally, mostly thanks to the conclusions of the international missions of the OSCE, NMO, NDI, Canada, and the European Parliament that clearly pointed to the fact that Ukraine had conducted a democratic election in 2019. That's why, in spite of the fact that both the parliamentary election in Ukraine of 2019 complied with international standards for the democratic election, in Ukraine, given this active hybrid Russian aggression, Ukraine should continue inviting international missions of the observers to its elections in order to ensure fair assessment of the election campaigns for the Ukrainian citizens and the international community. Besides, Ukraine should make sure that quite a large number of well-known Ukrainian journalists would visit Ukraine on the eve of the election campaigns and to inform the international community about the real situation in Ukraine, including its election process. Today, all the democratic countries pay a lot of attention and efforts not only to secure their own election process, but also to affirm confidence in it among its people and the international community. The authorities of Ukraine need to take the international experience into account as they have to counter disinformation, particularly during the election campaigns, to promote fair and democratic elections in Ukraine. As an example, in 2017, the President of France, Emmanuel Macron, explained that he had not given access to representatives of two Russian agencies to his own headquarters during the presidential election because, in fact, they were the agents of influence and untrue propaganda. The Supreme Court and the Ukrainian administrative courts will play a very important role in this respect because they will need, in their decisions, to protect the freedom of expression as well as to ban propaganda directed at undermining the election process and confidence in it among the citizens of Ukraine.
It is necessary to resort to other strategies in Ukraine and beyond because disinformation channels are diverse. Due to that, it's even more important for Ukraine to keep in mind 25 million of diaspora when it comes to exercising monitoring with respect to disinformation against Ukraine and to develop countermeasures to combat disinformation. As to media monitoring, our mission provided 8 recommendations to combat disinformation, and that includes election campaigns in Ukraine. The first is to increase the level of awareness as to risks and threats of disinformation for political stability, social economic well-being, and protection of fundamental freedoms. Number 2, to develop strategic program of combating disinformation, which is an important element of hybrid aggression of Russian Federation against Ukraine. 3, to set up commission to coordinate different stakeholders, actors engaged in the process of prevention, identification, analysis, and combating disinformation and its negative impact. 4, organized monitoring group composed of diaspora representatives that would, on ongoing regular basis, monitor mainstream and social media in their respective countries to identify manipulations and disinformation about Ukraine at large and democratic processes in Ukraine in particular. 5, establish cooperation with the governments of Western countries and international organizations to exchange experience and information to effectively deal and combat disinformation and have coordinated efforts, concerted efforts to deal with this phenomenon globally. 6, find effective ways of cooperation with Google, YouTube, social media such as Facebook, Instagram, and Twitter, and communication platforms, WhatsApp, Viber, and Telegram to combat disinformation dissemination. 7, invest in media awareness among Ukrainians to include disinformation and manipulation issues through specialized trainings and critical thinking subjects and media literacy subjects to be introduced into schools and institutions in their curricula. 8, contribute to the development of independent, high-quality media outlets that would effectively disseminate truthful information about Ukraine among other different audiences in other countries. Hopefully, these conclusions and recommendations will be useful to improve election process in Ukraine, and I'm sure that Ukraine will develop its election law in civilized, democratic manner. Thank you for your attention. Thank you very much, Eugene, for your presentation. Secondly, today is a national holiday, Day of Canada, so we would like to congratulate you on this holiday. On June 1, 1867, the act was signed whereby 3 provinces got united into a state called Canada. Thank you. The next presentation. Then the Constitution states that people are the bearers of power, and administrative courts are to protect the fundamental rights of citizens. Election rights are the key rights when it comes to fundamental rights of people. Therefore, the next presentation is very important. That's the judicial protection of electoral process as the safeguard of the constitutional rights observance of the participants. That's going to be made by the Judge Prudivis, Judge of Zaporizhia District Administrative Court. Good afternoon, dear colleagues. It's a real pleasure to see all of you. And it's nice to see Dr. Broker personally. Happy to see you. Let me congratulate all participants on the days of the Administrative Justice and Constitutional Administrative Court of the Supreme Court for the 4th time organizes this reputable event. That's a scientific conference that we are enjoying today, and I would encourage all of us to keep having this event regularly. That motivates us, and that's a very good opportunity to get updated about the recent research that we are involved in. The subject matter of my presentation re-echoes the the title of the conference, and as Olena said, this angle seems to be the core one, because the exercise of electoral rights by citizens of Ukraine as a young democratic state is the most pertinent and painful, since election process is becoming sort of permanent in our country, and it reflects actually the political processes that we see in Ukraine to build democratic state. Let me start my presentation by saying that scholars single out 5 major forms of protection of electoral rights of citizens, the protection of the rights and freedoms by the state, the municipal, civic, and international protection. However, among the 5 mentioned, well, they could be categorized differently, naturally. I am a supporter of this type of categorization, and out of these 5 groups, I would single out one of the most effective. That's protection of the rights and freedoms by the state, public protection. Public protection of the rights and freedoms of citizens in electoral process is divided into subgroups too. We can talk about administrative form of protection, so that's a direct applications to election commissions with complaints. But the most powerful, from my perspective, form of protection among the 5 outlined by me and among the or within the public form of protection, the most effective is the judicial protection. As of today, judicial protection of election rights of citizens is exercised by administrative courts, and we are celebrating the anniversary of establishing administrative justice in Ukraine. But it's not just pure celebration of the event. As the judge that was involved in establishing administrative justice in our country, I would like to say that administrative courts is the youngest branch of judiciary in our country. But for the time it has been in place, for the time of its development, it proved to be the one with high level of legal culture, and I would even call it legal revolution, because administrative courts were set up on the new revolutionary principles and basis in Ukraine. The rest of the jurisdictions had existed in Ukraine in the Soviet times, but young Ukrainian democracy introduced administrative justice and the principles it is governed by, and that includes new approaches, the principle of applying norms of European Convention and European Court judgments and European approaches when deciding various types of disputes. And in this case, we are talking about electoral disputes. All this was done by newly established administrative justice in Ukraine. So it's very important for the protection of the core constitutional rights, election rights of citizens. It's very important that it is administrative courts that deal with this protection. A bit of statistics. To quote, statistics is taken from scientific research of Dmytruk analysis for the period of 18 months, starting January 1, 2019. The number of cases decided by the administrative courts with respect to protection of electoral rights and violations of electoral process. As to the rights to appeal action or inaction of the election commissions, there were 1,425 decisions made. As to the voters list, 1,142 decisions, actions or inactions of local authorities, institutions, organizations appealing their actions or inactions, including media, 5,119 decisions, appealing actions and inactions of the candidates, political parties, local organizations, their officials and designated persons, observers, subjects of the election process. 1,109 decisions. More than 10,000 decisions were made with respect to presidential elections. I think that these statistics speaks about the role of administrative courts in the system of the protection of electoral rights of citizens. Talking about performance of this function of the administrative courts to protect the electoral rights of citizens. Administrative courts are the most progressive with due respect to other jurisdictions. But from my perspective, administrative justice is the most progressive in Ukraine versus other jurisdictions in our country. And apart from using the principles of European Convention and European court case law, I'm not saying that other jurisdictions are not applying that, but administrative jurisdiction was the first to do that. In addition to that, administrative courts, when resolving electoral dispute, apply to other principles, the principle of lawfulness and rule of law. Now, as to entities that can apply to administrative courts to protect electoral rights. This is covered by electoral court and administrative court. All parties to the process, election process, can go to administrative court, but one thing is concerning here. Can they go to the courts only in case when, for instance, voters' rights are violated as the subjective rights, or if subjective rights of the voter are limited to the voting procedure only, or they are much broader, or only in the case of the violation of the subjective right of the voter can go to administrative court. This is a pertinent question, and there are various approaches as to handling this question. It seems to me that we need to keep in mind that subjective right of a voter is not limited to just the procedure of casting vote, this procedure, but it is much broader. And it seems to me that we need to decide this matter in favor of the subjects of the election process, that is, the citizens of the country, so that they could go to the court not only in the instance when their subjective rights are violated. Effective administrative code, and that's a procedural code that determines the procedure of considering cases that are linked to electoral process as well, is very effective in establishing the fundamentals for considering this group of cases, starting from the expeditious consideration, composition of the court, up to the seeing that the decisions should be issued immediately, and the party should be immediately informed about the decision in full. It seems to me that these provisions reflect the main principles of the election process. That's awareness of people, of the procedures, and if citizens go to court to protect their rights, then they are immediately aware how the court can protect the rights of people. And people do not agree with the court decision, then they can quickly go to the Court of Appeal to appeal the decision. It seems to me that we need to take into consideration some administrative code provisions that establish sole judge panels, and when it comes to the commissions, for instance, I think there is a question here whether the sole judge consideration of the case should be maintained here, because here we are dealing with the claims to appeal the decisions of the CSC, and if it is a sole judge decision that can do that, then I believe that in the instance of this type of disputes, we'd better have the panel, the judges, for the sake of objective consideration, impartial consideration of the cases. I do understand why the provision was introduced. It was to speed up the consideration process, given the number of judges working in courts. At the moment, we know that courts are understaffed, but this question remains open, and I tend to think that if it is election process-related case, especially when it comes to action or inaction of the election commissions, then it would be better to hear these cases by the panel of judges. Another feature of the electoral disputes is the degree of conflict inherent for the disputes, and it puts a special importance and weight on the court, because conflict nature of disputes is typical of all cases that are linked to elections. And getting back to what I started with, that's forms of the protection, courts are the most effective when it comes to handling all this conflict type of situations. And it seems to me that the trust to judicial protection of the parties of the election process is the highest, and the number of decisions that I stated at the beginning supports that. So getting back to the celebration of the administrative jurisprudence days, and getting back to the administrative justice being the most progressive in the system of judiciary in our country, I believe that it is really right that both practitioners and scholars point out that administrative courts are the most effective in protecting the rights of the parties of the election process. And I do believe and hope that administrative courts will be further strengthened, and the credibility of citizens to these courts will stay high, since the courts are the bodies that are perfect in protecting the rights of the electoral process.
Цьому завершувати свою доповідь. Основні меседжі я висловив. Якщо детально, я...
I don't want to take more of your time. I think I have told you everything I wanted to say. More details can be found in my report, ready for publication, if anyone is interested. And if you have any questions, I will be happy to answer them. Thank you. Thank you, Mr. Prodivus. Thank you for your presentation, and especially thank you for the kind words targeting the administrative justice. Thank you. We have one more presentation. Who is the judge, the secretary at the Grand Chamber of the Supreme Court, Doctor of Law, Vsevolod Knyazev, who is going to speak about the legal opinions of the Grand Chamber of the Supreme Court in election-related election disputes. Thank you, Elena. I'd like to greet all the participants of this conference. I'd like to join all the words of greetings on the occasion of the Constitution of Ukraine and the days of administrative justice, as well as I'd like to greet our friends from Canada with the Canada Day that, as we heard, was celebrated today. I think it is quite symbolic that this conference is taking place now, because it is in the Constitution of Ukraine that the main foundations of the election law are enshrined, guaranteeing the election rights to the Ukrainian citizens. And it is the administrative courts that hear those disputes. That's why it's very good that such a conference is taking place right now. And I'm grateful to all the organizers for having selected such nice dates. Legal opinions expressed by the Grand Chamber of the Supreme Court regarding election disputes. That's my subject. I won't take a lot of your time for the information you have already heard today. Let me proceed to the essence of my presentation at once. As other speakers have covered a lot of ground today, you've heard a lot of interesting information. So let me proceed to the most important positions for the judges as they hear election disputes. Next slide, please. I'd like to start by saying that the Supreme Court, as the first instance court, has jurisdiction of the cases in terms of the Central Election Commissions establishing the results of the voters as regards inactivity of the Cabinet of Ministers of Ukraine that fails to submit to the Parliament the draft laws that on the cases that are important for the Ukrainian nation, the decisions, actions, or inactivity of the CEC in terms of establishing the results of elections or referendum. That's what Articles 22 and 273 of the Code of Administrative Offenses establishes. The Grand Chamber of the Supreme Court that I represent today is the Court of Appeal as regards the disputes that are heard by the Supreme Court as the first instance court. And therefore, those election disputes that are heard by the Court of Cassation are further reviewed by the Grand Chamber as the Court of Appeals. Therefore, the Grand Chamber of the Supreme Court is the administrative court of that category of cases, and it actively participates in the formation of the case law in this category of disputes. Here's some statistics as regards what the Grand Chamber has done in the past 3 years in terms of election disputes. We see that all in all we have received 52 appeals in terms of election process. Most of them were about parliamentary elections. Fewer of them were about the presidential election. The Grand Chamber rendered 35 decisions. Most of them dismissed the complaints, upholding the first instance court decisions. Most decisions rejected the appeals, which means that there is communication, a good understanding with the judges of the Administrative Court of Cassation. Okay, of course, there are sometimes situations when the Grand Chamber has a somewhat different opinion about interpretation of a certain provision, legal provision. But basically, we're like-minded people, and our legal positions usually are the same. Still, the legislators that use the Constitution of Ukraine, which suggests the right of appeal to everyone, has said that in a situation where the Supreme Court is the first instance court, the right to appeal should be granted to everyone, therefore giving the Grand Chamber the role of the Court of Appeals, including in election-related disputes. If we look at the problems that mostly were given to the Grand Chamber in terms of election disputes, usually these were the issues of identifying the jurisdiction of the cases as regards the requests to consider the actions or inactivity of the CEC invalid. The Grand Chamber really had the majority of cases of this type, and in most of its decisions, the Grand Chamber ruled on the jurisdiction of some cases, for some of them, the most important ones that I'm going to tell you about. For example, in the resolution of the 18th of January 2021, the Grand Chamber pointed to the difference between the competence of the CEC, own competences, and the control functions of the CEC in terms of the establishing election results. And the situation with the Central Election Commission, guided by its own competences, authorities, draws a proper protocol and makes the decision. In that case, those decisions of the Central Election Commission are within the jurisdiction of the Supreme Court as the first instance court. At the same time, when the Central Election Commission as it uses the legislation when it finds violations by the Territorial Election Commission, when it takes over the competences of the TECs, and the CEC has that power in case of systemic violations by a Territorial Election Commission, where it is impossible to establish results of the election in a certain territory for a long time, the CEC can take over those functions. In that case, as it takes over those competences, it still uses its functions of control, which means that it is not its own powers, but in fact these are the powers of the Court of Appeal that works in the territory of the city of Kyiv, which is the 6th Administrative Court of Appeal, which in that case has the jurisdiction over such disputes. The next problem that the Grand Chamber of the Supreme Court faced was the wrong instance jurisdiction of the requests to invalidate the decisions of the CEC to establish the results of the voting in the single mandate constituencies, as well as decisions of the CEC quashing the registration of the candidates or announcement that a certain candidate has become a member of Parliament of Ukraine. Such cases should be heard by the 6th Court of Appeal instead. The Grand Chamber has expressed this position, suggesting to combine different claims in one lawsuit. I think that that legal position is important not only for election disputes. It is actively used for other categories of disputes. What is it about? There can be situations when the claimants combine in their claims the requests that have exclusive jurisdiction with different types of courts. In that situation, Article 169 of the Code of Administrative Justice suggests that it is impossible to combine within one claim or lawsuit the claims that are to be heard by different courts. For example, in this case, whose number you see on the screen, the claimant has brought together in one's claim the requirement to invalidate the decisions of the CEC on establishing results of the parliamentary election, as well as asked that the decisions of the CEC should be invalidated in terms of registering such a member of parliament or candidate MP. In that case, the first requirement is to be heard by the Supreme Court of Ukraine, while the second one can only be heard by the 6th Administrative Court of Appeal. In other words, it's impossible for the Supreme Court to hear this case. What should be done in that situation? The Grand Chamber asked itself, because the first instance court decided to separate those claims and only work on the ones that it had the jurisdiction over. However, in view of Article 172 of the Code of Administrative Justice, it would be impossible to do it, because the claims can be separated on a situation where both claims, as Articles 172 says, are within the jurisdiction of the court that is to separate the claims. After separation, both of them stay with the Supreme Court, for example, but clearly that the second requirement is not within the jurisdiction, as the Supreme Court is the first instance court. And what to be done in that situation? We can find the answer in Article 169 of the Code of Administrative Justice, which says that in this case, the claim should be sent back to the claimant, and the claimant will have the right to submit one's claim that would comply with Article 169 and 172 of the Code of Administrative Justice. As part of this and further cases heard by the Grand Chamber, a very interesting question was brought up. In that situation, if some of the claims are within the jurisdiction of the Supreme Court, like establishing the election results, while others are outside of it, but within the jurisdiction of the Sixth Court of Appeal, for example, some interim decisions rendered by the Central Election Commission before it decided to establish the election results. What should one do in that case? Because it's a very strange situation occurring when the actions about establishing the results will be appealed with the Supreme Court, while other decisions that the CEC could have rendered on the same day, some interim decisions, supporting decisions for establishing the election results, its actions to draw the protocols or to request proper documents could also be appealed. However, according to the law, they can only be appealed with the Sixth Administrative Court of Appeals. So it's a strange situation where the claimant would find oneself in a very difficult situation where one cannot appeal all these things at the same time with the Supreme Court on the one hand. On the other hand, if it appeals a certain action with the Supreme Court, while the previous interim decisions would be appealed with the Sixth Administrative Court of Appeal, in both places, the deadline for hearing those cases is 2 days, and there may be a very strange situation where the Supreme Court will hear the case and would say that the results of the elections have been established correctly within 2 days, while the Sixth Administrative Court of Appeal would say, no, it's all incorrect, all those interim decisions were unlawful, and the legal certainty principle would be violated. The first situation, the first idea would be to give this right to the Supreme Court, but that runs counter to the Code of Administrative Justice, and hearing them separately is impossible because the decisions could be contrary to one another. Suspending its work, the Supreme Court cannot do it because the deadline is 2 days in order not to stop the non-stop process of
Given all that, Grand Chamber came to the conclusion, and I believe that it is the correct one and should be applied by the courts of other instances, namely the decision about the results of the elections made by the CEC is subject to appeal. All the previous actions of the CEC is the ground for the claim, and they shouldn't be stated separately as a separate claim in the statement of the case. While all this should be stated in the reasoning part of the claim, stating that these sections were wrong. So that's the report that was issued with violations, and the claim that is referred to the Supreme Court would be to find the actions of the CEC unlawful as to establishing the results of the elections. Then this tool of protection would be really effective, and it would protect the rights of the claimant in the election process. So the Grand Chamber clarifies this position in several resolutions, but that's a kind of a summary of this opinion. And well, yeah, I sort of provided the conclusion. Next slide. Grand Chamber also had an appeal against the actions of the CEC that followed the results of the election established. The Grand Chamber established that CEC with respect to making public of the names of the people's deputies in Голос України, урядовий courier is not the mandate of the CEC, but that's the other bodies that are in charge of that. Next slide. Legal position of May 17, 2021 in the case that you see on the screen. The issue there was the following: inaction, that was the appeal against the inaction of the CEC with respect to establishing the election results. The law states that the appeal against the decision of the CSC with respect to the results should be done at the Supreme Court. When it comes to inaction of the CSC, this should be done at the Sixth Administrative Court of Appeal. Grand Chamber explained where to go to complain against inaction of the CSC when the CSC does not establish the results of the elections within established time. So that's purely the file of the CSC. Then the Cassation Court decision was not upheld. The former said that it should be a complaint with the Sixth Court of Appeal. The Grand Chamber said that inaction of the CSC with respect to establishing the results of the election falls within the disputes as to the results of the election, and it should be considered by the Supreme Court, and the Grand Chamber should act as the appeal instance. Having analyzed the decisions of the Grand Chamber for the period of 3 years and a half, you can make a conclusion that most of these disputes dealt with the elections of the people's deputies under the old law that is partly ineffective because the system of elections has been changed from majoritarian to proportionate because majoritarian was deficient and allowed for abuses, fraud, and this led to a large number of disputes handled by the courts of all levels, including Supreme Court and Grand Chamber. This law is effective only with respect to interim elections. When it comes to the new parliament, members of the parliament will be elected under the new election code, that's proportionate dispute. So we can assume that most of the disputes we are discussing today are no longer be valid. Yeah, so because there's going to be a different legislation that will be guided by then. A number of resolutions of Grand Chamber made this year and last year one of the cases on the screen is the number 9901437. Another case is of last year that deals with the limitations of the CSC with respect to repeat elections and finding the results of the parliamentary elections under majoritarian system as invalid. It was remedied by the election code. We haven't had any disputes under this category as established by the new code. It seems to me that the situation should be improved. In case of the falsification and the majoritarian system of the members of the parliament, the powers of the CSC are limited to correct the situation. Sometimes the Grand Chamber stated that there is a violation, but the CSC, given the powers it has by law, cannot remedy this violation. So we suggested amending legislation to provide these powers to the CSC. We support the model when the district election commission can appeal to the Oblast Administrative Court, and then CSC cannot really interfere. This can be done only in limited exceptional cases, and then Supreme Court cannot interfere with the processes either. But with the introduction of the new election system, hopefully this issue will no longer crop up. Another interesting legal position expressed by Grand Chamber was the position in this case, that's to secure the claim. It's the issue that is widely discussed in the administrative courts. We got used to the idea that the claim is not secured in election disputes, but Grand Chamber noted the difference between the election process and holding election. Article 61 does not allow for security of claim in any way that can stop election process. It was noted that election code provides for several stages of the election process, and holding elections is one of the stages, but it's not the final one. Therefore, the conclusion was made that it is impossible to secure the claim at the stage of holding elections, and the stage of holding elections it's just one of the stages, and later the Grand Chamber came to the conclusion that when it comes to the appealing the results of the elections, to secure the claim by banning registration of the candidates, that seems to be proportionate and effective. What does it mean if the decision of the CSC is appealed before the Supreme Court, and the decision establishes the results of the elections, parliamentary elections? The law establishes that when the member of the parliament has sworn in, so the decision cannot be revoked, because after swearing in, so the candidate is becoming a member of the parliament, so no decision can be made. So we have 5 days to appeal the decision, 2 days to consider by the Court of Cassation, 2 days to appeal before the Grand Chamber, 2 days for the Grand Chamber to handle it from the moment when the CSC makes the decision. So that's a certain number of days, 11 to be more exact, in the course of which the candidate can get registered, and the decision about his victory at the elections can be made public, and that's the time when he can swear in. But if the CSC's actions were unlawful and the Supreme Court found them unlawful, it wouldn't have any effect, and therefore judicial protection is undermined for the candidates that can appeal this decision. Therefore, the Grand Chamber said that the claim can be secured in this type of disputes after establishing the results of the election by banning registration of the person that was elected member of the parliament, to protect judicial protection of other persons that can appeal these decisions of the CSC. So these are the positions in election disputes that I wanted to cover. There are a lot more, but given the time that was allocated to me, unfortunately, I can't cover all interesting cases that Grand Chamber heard in the course of 3 years or so. The presentation and the article that I provided, hopefully the participants will receive that. Well, this presentation includes a lot more details, and at the moment that's it that I wanted to share with you. Thank you very much for your attention. We'll be happy to answer any questions if there are any. Thank you. Thank you for your presentation. Unfortunately, that's all we had time for. I'm just double checking the chat. I don't see any questions. So let me conclude the second session, and let me conclude by the first day of our conference. Tomorrow we are starting at 10. We are going to have session 3, that specific features of proceedings related to the election process. It's going to be moderated by Miroslava Bilak, judge of the Supreme Court of the Administrative Cassation Court, Doctor of Law. That's it for today. Thank you very much for fruitful cooperation with you. Enjoy a night and looking forward to seeing you tomorrow. Bye. Thank you.
Всього найкращого.
All the
Все
best.
добре всім.